Hi, I'm Megan. Let's keep this case brief. I'm on a crim pro kick, so let's do Blackledge versus Perry. So we've talked about selective prosecution, but now let's talk vindictive prosecution, which is also illegal for a prosecutor to do. So when you're charged with a crime, there are certain rights that you have. You have a right to a speedy trial, you have a right to counsel, you have a couple of rights as established by the U.S. Constitution. And if you want to exercise those rights at any point in your case, that's up to you. Vindictive prosecution is when the prosecutor punishes you for exercising one of those rights. And that's illegal, and a prosecutor can't do that because you're not allowed to be penalized for just exercising your rights as given. But again, you're going up against a prosecutor, you have a big hill to climb. So how does Perry do it in his case? So the story goes as is. Perry is an inmate, he's in prison already for a different crime. And he gets into a prison fight, and somebody gets hurt because he's carrying something that he shouldn't have. However, in the particular state that he's being institutionalized in, which is North Carolina, a defendant convicted in a district court has the right to a trial de novo in a superior court. A trial de novo basically means you get a new trial based on an entirely new case. So, Perry says he wants a brand new trial. Prosecutor doesn't exactly like that. So instead of sticking to the original charge to bring forward an entirely new case in the superior court, the prosecution actually ups his charges to felony assault with a certain type of thing with an intent to cause some serious damage. And Perry pleads guilty. He doesn't really have too strong of a case, and what's he gonna do? He's an inmate. He's already in prison. However, he appeals this and says, this was supposed to be a misdemeanor. It got up to a felony for some reason, and I think it's because I said that I wanted a brand new trial instead of sticking with the misdemeanor charge. I was going to have my day in court, but it should have been on a misdemeanor, not a felony charge. I think that the prosecution was just being vindictive because I said I wanted a brand new trial, as I'm entitled to. And so the judges look at this appeal and they say, you know what? I think Perry's right. This felony case is based on the exact same conduct as the misdemeanor case. Nothing changed factually. The felony charge just makes this case all the more severe. The thing is, it's a little bit harder to fight a felony than it is a misdemeanor. And the prosecutor likely didn't want Perry to go back and try to fight a misdemeanor. It's a little bit harder to fight that felony, and he might stay quiet. The prosecutor doesn't want to go back to court. Court's expensive, it's timely, it's time-consuming, he just wants this done and over with. And the fact that Perry was asking for a brand new trial and he just happened to get a felony charge after asking for that is very, very fishy. However, that's not fair to even inmates because you should have the right to appeal whatever charge has been brought against you. Whether or not you have the right to appeal your case shouldn't rely on whether or not the prosecutor wants to go to court that day. You shouldn't feel threatened into accepting a higher charge just because it's a higher hill to climb. That's called a violation of the Due Process Clause, and that is unconstitutional. Therefore, we have here a successful case of vindictive prosecution. And if this case teaches you anything, you get to be petty. The prosecution does not.